Hi, my name is Taylor, and I am a member of the jury for this case. Sorry. Before I disclose my decision regarding who is innocent or guilty, let's go over the case facts first. The defendant, AU Hospital, was given a subpoena for Jennifer's medical records. AU Hospital then disclosed Jennifer the plaintiff's information to the court. Jennifer stated that she did not receive notification of this subpoena and therefore was unable to make a decision regarding whether or not she wanted her information disclosed, and that AU Hospital failed to ensure that the subpoena was legitimate documentation. AU Hospital admits that they failed to contact her, but they also state that they were in the clear to release her information to the courts because Jennifer did sign a consent form allowing them to release her information. This consent form stated that AU Hospital could in fact release medical records to doctors, referred doctors, and follow-up care. Jennifer, however, notes that nowhere in the document does it say anything about releasing information to the court, and therefore AU Hospital violated her right to privacy. AU Hospital also states that the subpoena was legitimate legal documentation because it can be issued by an attorney who practices law. Jennifer is stating that AU Hospital failed to protect her rights as a patient by mishandling her private information. Also, a subpoena issued by an attorney instead of a court order is not quite enough to require the hospital to simply hand over her records. A subpoena is a request for information to be used in a particular case. In 2004, Patricia Arzuaga discussed HIPAA and health plans. And when we're talking about like privacy and patient confidentiality, health plans, like health insurance companies, have to go on the same laws or regulations as hospitals do. So AU Hospital would have to comply with what Patricia is saying. She said, if a health plan receives a subpoena from a party other than the court, it must, before disclosing any protected health information, either 1, obtain satisfactory assurance that the notice or protective order requirements have been met, or 2, make a good faith effort to satisfy the notice or qualify protective order requirements itself. In addition, a health plan may disclose only the minimum necessary information to meet the purpose of the disclosure in compliance with the subpoena. Also, as noted in the discussion of recent case law, a health plan will need to consider whether applicable state laws and additional procedural requirements before the plan may disclose such health information. So the main factor here is that in order for this whole, in order for AU Hospital to be not in the wrong, I guess, they would have had to prove that they tried pretty hard to get in contact with Jennifer, because Jennifer is the one that had to say, yes, you can disclose my information, or no, you can't do that yet. And they failed to contact her. So that's a major factor in this. AU Hospital also admitted that they released information to the courts in fear that they would be penalized for not releasing Jennifer's medical information. So, to me, no, this is just to me, it sounds like AU Hospital knew that they weren't supposed to release Jennifer's information, but they did it anyway because they thought they were going to get in trouble. But really, HIPAA is a federal regulation, so as long as they followed HIPAA guidelines, then they really didn't have anything to worry about, but they didn't do that. So given all of these facts, if it were up to me, I would rule in favor of the plaintiff, Jennifer.